This is the 5th anniversary of the Center on the Legal Profession, and no birthday should go uncelebrated. Oftentimes, for nonprofit institutions, they are opportunities for fundraising. You will be pleased to know that this is not one of such an occasion, but it is a chance to say thank you to a number of people who have made its work possible. And first, I want to recognize Amanda Packel, who is the first executive director of the center. Amanda, do stand up. She's unwilling to take recognition, but she was so instrumental in the founding of the center, and she has now been so ably succeeded by Lucy Rica, who's the current executive director, and who bears so much of the responsibility for events like this. So thank you to both of you. And thanks also to Dean McGill, who's just been an unflagging supporter of the center. And it's a rare opportunity that you have a chance to say in public what you've said so often in private, which is how much that support has meant to all of us, and your championship of public interest, access to justice issues in particular, which are the subject of this anniversary celebration, is really important to building a culture of commitment at the law school. So thank you, and I'll let you introduce our distinguished speaker.
Well, thank you all for being here. Thank you for your kind words, Deborah. It is a joy and a pleasure to be supportive of the work that you're doing and that the center is doing. As Deborah said, this is the 5th anniversary on the Center for the Legal Profession. It was founded in 2008 by Professor Rohde, who is the Ernest McFarland Professor of Law at the Law School. Her commitment, as many of you know in this room, to access to justice and study and knowledge of the profession has been unwavering, not just in the last 5 years, but her entire career. She's been a leader as a scholar and a teacher and a mentor in those fields. The center's mission, of course, is to support and engage in research, in teaching, in programming, and outreach and public policy on crucial issues that are facing the profession. Within that broad mission, the center has chosen to focus on some specific issues, in particular legal ethics, which is one of Deborah's areas of expertise, regulatory reform in the profession, challenges to the practice, corporate practice specifically, innovation in the profession, and of course, near and dear to all of our hearts, and Deborah's particularly, access to justice. Under the leadership of Professor Rohde and the two executive directors who she just recognized, Amanda Packel and Lucy Rica, the center has been an incredibly dynamic place for conversation and learning on these issues. It's furthered its mission in many ways. I wanted to mention just a few of them. In 2008, when it first started, the center was involved in an important project called the Roadmap to Justice Project. It also participated in the establishment, along with the ABA and the Harvard Legal Center on the Profession, in the creation of the Access to Justice Consortium in 2011. It sponsored many conferences and forums on pro bono and public interest work in the profession, including involving retired attorneys in that effort. Published a report on access to justice issues in legal education just 2 years ago. And it most recently authored a piece on the unauthorized practice of law, the enforcement practices therein, and possible strategies for reform. In addition, next year, the center is going to be the host of a group of fellows who are focused on innovation and technology and change in the profession, including a focus on increasing access to justice through those means. I think it's fitting then that the keynote speaker for today, this celebration of the 5th anniversary, is the Honorable Jonathan Lippman, who is the Chief Judge of the State of New York and the New York Court of Appeals. Judge Lippman was appointed in 2009. He presides over an enormous court system in the state of New York. It has a $2.3 billion budget, 3,400 state and locally paid judges and over 15,000 non-judicial employees in over 350 locations in the state of New York. You probably know Judge Lippman not for this massive administrative job that he has, which is truly massive, but also for his activity in reform of the profession. Since taking office, he has been a relentless proponent of reform of the legal profession, and in particular, access to justice for the poor. He's championed equal access to justice. He's taken a leadership role in identifying permanent funding streams for civil legal services in the state of New York. He's strengthened the state's indigent criminal defense system. He's established an effort to identify the systematic causes of wrongful convictions in the state of New York. He's addressed the increasing number of foreclosures that are entering the state court system. He's worked to reform New York State's juvenile justice system, and he's created human trafficking courts across New York, and he's done many other things. This is just a list of some of the few efforts which are innovative, have received attention in many other court systems, and the state, under his leadership, has been a model that other courts and other bars have looked to change their own systems. Chief Judge Lippman, well known to us, made the New York bar system the first state in the country to require 50 hours of pro bono related activities prior to admission to the bar in the state. He also established a pro bono scholars program to help alleviate the crisis in access to civil legal services and accelerate bar admission. He is, in this effort, as in so many others, a national leader in change in the profession, and that's why it's so fitting that he is the keynote speaker today on the 5th anniversary of the Center for the Legal Profession. Please join me in welcoming Judge Lippman.
I want to thank Liz for that lovely introduction and for inviting me to this great law school, which everyone, including the legal community in New York, so admires and respects. And I couldn't be happier to be with Professor Deborah Rohde in this 5th anniversary celebration of the Center on the Legal Profession, which, as far as I'm concerned, deals with so many of the issues that are dear to my heart, what we're trying to do in New York, and to kind of level the playing field for all who come into our court systems, come to our profession seeking justice and seeking help. So the 5th anniversary celebration is very important because we have much work to do and many more years of the center doing its work and many more issues relating particularly to ethics in the profession and access to justice. We have much left to do. So let me today talk about, first and foremost, the crisis in access to justice in the country, and in particular, in civil legal services for the poor. That really affects New York, California, and the nation. I want to talk about how that crisis manifests itself, the solutions, the problems, the obstacles, obviously informed by my own experience as the Chief Judge of New York, talk a little bit about judicial leadership, about public funding, about the responsibility of the bar to do pro bono, about the role of academia, about rethinking legal education, about emerging issues in the field of access to justice, about the regulatory scheme for lawyers and how it affects access issues, and really kind of try and tie it all together as to where we're going in this area of access to justice and what we hope to achieve. I'm going to do all of that in about 30 minutes, if that, and then I hope we'll have time for questions. I will try not to be too provocative, although Deborah wants me to be, and is my want, but I do think part of my role is to stimulate thinking and discussion. So let me tell you what's on my mind. First of all, obviously, there's a crisis in access to justice, and there's a justice gap in this state, in our state, my home state, in this country, between the finite legal resources available, and yet the dire need for legal services, particularly among the most vulnerable in our society. California uses the number of 4.3 million people who come to their courts unrepresented. We use a number of 2.3 million. I don't know exactly what it is, but suffice it to say that there are loads of people coming into our courts who are unrepresented. And beyond that, people who need legal help who aren't even close to the courthouse yet. So much of this need for representation starts even before they get to the courthouse and avoids coming to the courthouse. 16% of the people in California and New York live at or below the poverty level. Some say it's as high as 18 or 24%, depending on which numbers you look at. The Legal Services Corporation in Washington is under attack, constantly having its funding limited. The IOLTA funding around the country in New York went from $36 million to $6 million in 1 year. And in California, from $22 million to $7 million in 1 year, virtually overnight, because of the interest rates on lawyers' accounts. Legal service providers, depending on how you look at it, turn away 3 out of every 4 or 4 out of every 5 people who come to their doors seeking assistance. We are at best meeting 20 to 25% of the need for legal services for those most disadvantaged. So, based on this, how do we attack the problem? I'll tell you a little bit about how we've done it in New York and the issues that I think are important. When I became the chief judge, I didn't come in saying, gee, I'm going to attack this access to justice problem. One of the first things that happened was the legislature invited me to come speak about long and short-term strategies for civil legal services in the state. And while the chief judge generally does not appear before a legislative hearing, this issue was important to me, and I agreed to do it. What I recognized during that hearing was that New York had no short-term or long-term strategy to deal with civil legal services, none whatsoever. So that led me to try and create a New York template for dealing with it. And I started by appointing the task force to enhance civil legal services in the state, headed by a former head of the Legal Services Corporation in Washington. And I note that California had an Access to Justice Commission, which is the equivalent, in the late 90s, already appointed it. And I'm pleased in the new task force, the Civil Justice Strategies Task Force, the State Bar, and California is addressing these issues. And the first thing we focused on was public funding. That basically in New York, we had no public funding for civil legal services. There were a few member items that came out of the legislature, the old kind of pork barrel thing in your local district. If you could have a worthy cause, you could get a few dollars. We decided, and the recommendation in the committee, the task force, and the task force and I worked very closely together. We decided to put our request for public funding for civil legal services in the judiciary budget. And we decided to do that because this is so fundamental to the judiciary's constitutional mission to foster equal justice. Aside from it being so fundamental to the ethical, moral obligations of the bar, this is what we're supposed to be doing by virtue of our Constitution. We looked at it and we said, okay, how are we going to get out our message? And we decided to hold public hearings on civil legal services, on access to justice in general. And we decided the leadership of the legal establishment in the state will do this. I will personally preside over those hearings, the presiding justices of the intermediate appellate courts, and the head of the State Bar Association, to show a united front and that this was something that was important. We emphasized that what we were interested in particular, was the people who are fighting for the necessities of life, the roof over their heads, their physical safety, the well-being of their families, their livelihoods was our focus. And we decided that these hearings must be counterintuitive in nature. We're not going to have the legal service providers come with their hands out and say, gee, we need money. Well, we know they need money. And we know they're doing God's work, and we know this is so basic. Instead, we wanted to have, and what we've done is have the heads of the largest banks in our state, the controller of the state of New York, the heads of the hospitals, the businesses, the landlords, come in and say, this is not only the right thing to do, but is essential for the bottom line of New York, that this is in our economic well-interest. And our latest reports show that for every dollar invested in civil legal services for the poor, $6 are returned to the state in lower social service, in incarceration rates, in more federal funding coming to the state. That is again, this is not another new do-gooder kind of thing. This is important for the well-being of our state. And that kind of has resonated and I think served us well. And I think the hearings also demonstrated that the judiciary and the profession stand for something in New York, that we're not just interested in feathering our own nest, but rather we have a noble profession that is guided by the well-being of our society and everybody, rich and poor, high and low alike. So that issue came to the fore immediately after we started these hearings that first year. As with California, we've had budget problems. We had a new governor coming in who decided that he needed to cut the judiciary budget in order to make the budget balance. And we had $170 million cut from the judiciary budget, which is a lot of money by any standards. I know you know big numbers here in California and big budget cuts. But in any event, that caused us to lay off 400 people in the court. And that same year, we put in the judiciary budget and got approved $27.5 million for civil legal services for the poor. And people were saying to us, how could you possibly do that? How could you lay off 400 people? And at the same time, who did you give that money to? Legal service providers? What is that all about? And what it's about, and what we try to make clear is, we don't want monies to keep the doors of the courthouse open if what happens inside those doors doesn't equate to justice for all, to equal justice for everybody. So we need to not only have enough money to run the court, we also have to have justice inside those courts. And I think that really had an impact in New York in terms of the priorities, at least at one branch of government and one constituency of this, public mosaic here, really felt this was an important issue. And we were trying to get across by these hearings that we need a reordering of priorities in our state, and that legal services for the poor is just as important as housing and hospitals and schools and all the other things that we deem important, that we hold dear. We don't say, gee, we don't have any money this year, so we can't educate our young or tend to our sick. And we can't say, and that's what happened when we started. The economy was terrible. And the answer, that the instinctive reaction is, well, that's great. Isn't that important? It's very nice. When we have more money, come back and see us, and we can, maybe we can help you. So it requires a reprioritization of really what our state, what our governments think is important. And as far as we're concerned, from the judiciary's perspective and the legal profession perspective, we have to understand that if the judiciary and the profession don't stand up for those people desperately in need of legal services, nobody else will. That's the reality of it. And the lesson from at least from my perspective, is that once we made that statement and people saw that the judiciary actually, again, stood for something, that it wasn't just about, let's give the judges, more pens or parking spaces or books or whatever, but we care about that principle of justice. Since that day, no one has touched our judiciary budget. We have had from $27.5 million, we went to $40 million, to $55 million, to this last year, current year, $70 million in the judiciary budget to give out in grants to legal service providers. And this really, to me, is the greatest protection. This year, we put in our budget, and the governor attacked our budget. We put in a bigger increase than everybody else had in the budget. And because the economy is a little better and you could have an increase. The governor said we're out of step with state government. But you know what? Nobody challenged our budget. Nobody challenged $70 million for civil legal services, because I think we've gotten across that this is a principled branch of government and a principled branch, a principled profession that is concerned with the public well-being and not with lawyers earning a lot of money or the judiciary having entitlements. So I think it served us very well, and we tried to make, for astute politician, and our governor is very astute, and he really has been very supportive, but you have to make sure that the other branch of the government, the public, understand that it doesn't help politically. It's not popular to pick on the judiciary, and even more specifically to attack helping those who need legal representation by having all these, again, counterintuitive is the only way I can describe it. People from the business community come in to testify. We had Cardinal Dolan come in his flowing red robe, come into the hearing on public hearing, with the red cap, and come in and talk about legal service report. I mean, the place was falling on the floor just listening to him, but very eloquent. But this is across the board. This is important. This isn't just, gee, this is another handout. Please give it to us. So public funding is great. We're very proud of all that public funding. It's wonderful. It's made a world of difference to the providers. But we all know that there isn't enough public funding in the world to meet this challenge. And we need the pro bono efforts of the bar to really make a dent into this justice gap. And I think the bar understands that we have a noble profession and is very supportive. And we have some great programs in New York. We say that they're giving, that they're doing $2.5 million hours of pro bono work. I don't know how many hours the bar gives. We make it up. So now, what we're trying to do with all the great pro bono programs and trying to tap all the different resources, whether it be corporate in-house counsel or baby boomers and everyone else, we want to know how we're doing. So this year we did mandatory pro bono reporting, and surprisingly enough, we had a real pushback, and it was surprising to me. The 7 other states have mandatory reporting, and the world has not come to an end. Everyone is fine. It's true. So we did this, and just many of the bodies, this is a voluntary thing. Pro bono is voluntary. We don't, that you don't have to tell us to do it. We're going to do it. And my answer is that this is very basic. This is not something we have to be kind of, well, should we do it? Should we not do it? This is the most basic area of professional responsibility. And I have to tell you, we didn't take a vote as to whether it was a good idea, whether the bar wanted us to require them to report their hours and contributions. Because again, we all have a role to play. The judiciary, as a regulator of the legal profession, has a responsibility. And that responsibility is not to serve the economic best interests of the bar. It's to promote public trust and confidence in the profession, and it's to promote the public interest. And we did this, and we've had some pushback, and we're working it out. It's a little family dispute that we're working out. But my point is this, that without the data, unless we understand how we're doing, we cannot possibly draw a conclusion as to whether our voluntary pro bono work on the part of the bar is successful, whether we're meeting our responsibilities as a profession. We cannot possibly know that. And this whole debate, which we talked a little bit at the roundtable that Deborah had arranged earlier today about mandatory pro bono versus voluntary, it's academic. We know whether we are meeting our obligation. We had 20 to 25 years ago a report in New York about mandatory pro bono that recognized it, that recommended it. And the chief judge at the time said that, gee, we ought to do this unless the bar steps up to the plate. And lo and behold, the results really didn't change over time, but we never did it because it's hard to do. Because in different parts of the state, we have, lawyers who are struggling to make a living. We have different geography in the different parts of the state. Rural lawyers have somewhat a tougher time than those in the city. There are all kinds of issues, legal, logistical, economic, that make it problematic, whether it's a good thing to do. I've said for years that I don't intend to do it. By the same token, I think it's got to be on the table. I think that we have to, this is almost basic profession. So I believe that we shouldn't make any grand pronouncements, whether it's voluntary, whether it's mandatory, but we have to do what's necessary to ensure that those most in need of legal services get it, and so I think the jury is out on that issue. I joked inside when we had this roundtable that I'm fond of saying that, I'm not, I don't know that I really want to do it. It's not my intention to do it. But as Seinfeld would say, not that there's anything wrong with it. Would it be good if every member of the bar in the state of New York and California gave 50 hours or 100 hours or more? Yeah, that would be great, So let's look at this in perspective, and we have to decide how we go forward on this whole issue. And the reality is that, again, we are the regulator of the legal profession. This is what we should be doing. We, the judiciary, should be muscular in terms of that responsibility that we have to regulate the profession and to lead the profession towards the most noble ideal of what we're all about and what it means to be a lawyer. We should use our bully pulpit, and certainly in the regulation of the profession, it's so important. It's critical. So we go from there, and you talk about pro bono. We also have to talk about the new generation of lawyers and what we do in terms of making sure that they have it on their foreheads, they have in their DNA this idea that what lawyers do is help people. What lawyers do is serve others. That's who we are. So we looked at that, and, there's a lot of talk today about law schools in general. President Obama says we should do away with the third year of law school, and I don't think he thought too much about that suggestion, but it's in the air, So how do we deal with it all? How do we give kids, law students, values and practical experience? So we don't have this discussion of, mandatory, voluntary. Everyone understands what it means to be a lawyer. So that's when we did this 50-hour program that requires every law student in the state of New York to give 50 hours of pro bono work before they will be admitted to the bar. We require it. We demand it. Because if you want to call yourself a lawyer in New York, you're going to have to understand and embrace our core values, what we're all about. And I'm so pleased that California is looking at this closely. And as I said inside, if New York and California do it, everyone will do it. And again, not a bad thing if every law student in our state and in the country do pro bono work, make a contribution to closing the justice gap, and understand in terms of value what it means to be a lawyer. I say if we teach them about torts and contracts, we should teach them about value. This is critical. This is what it means to be a lawyer. So the 50 hours does this combination of give them some practical experience and at the same time teach them some values and at the same time help to close the justice gap. We're the first state in the country to do it, and I want to be joined by California soon. And I know, John, you promised me soon. that we're gonna do that. So then, on kind of a variation on that, we're looking at this disconnect that's out there between the declining enrollment, not at Stanford Law School, but at many, many law schools around the country. Declining enrollment, greater debt burden, and fewer jobs, and yet this insane, dire, terrible need for legal services for the poor. How do we solve the disconnect? So the latest thing that we're doing in relation to law students is to say, we will let you take the bar exam while you're in law school. And when in your last year in February, if you have the necessary credit and you say and agree to give the last term of your law school career to exclusively to pro bono work, supervised by your law school and by wherever you're working, with a provider, with a corporation, with a law firm, we will find you the placement. But you're going to devote that again in the same vein of practical experience and making a contribution to closing the justice gap and understanding what it means to be a lawyer. So we're going to have a nice crop of students. There's a lot of out-of-state law schools have expressed interest in that program, and we really think it can make a difference. It can complement the clinical programs that law schools have now. And, you know, I want to say about law school, and, you know, it astounds me, and certainly not at Stanford Law School, where I go around the country speaking about this issue, and I have deans who tell me, you know, just very directly say, Judge, in all due respect, you know, we're not in the access to justice business. Well, no, we're not. And I, of course, say, in all due respect, you really are in the access to justice business. We're all in the access to justice business, whether it be academia, whether it be the judiciary, whether it be the profession, whether it be the provider, whether it be the corporate lawyer. We're all in the access to justice business. And so I think we all have a role. And certainly that includes the judiciary, the bar, and the academy. And there's no question about it. But these issues are almost easy compared to some of the new emerging issues in this area of access to justice and civil legal services. And I would mention in particular non-lawyer, which I know Deborah is very interested in, California is interested in. I believe that a non-lawyer trained in a particular niche can be far more effective than a generalist lawyer who we're trying to push into a particular area. Gee, we need some help. There is absolutely no, look at the medical profession. You know, the nurse will see you now. You know, not the doctor anymore, the doctor's assistant, the medical assistant. They got this a long time ago, that we cannot be so narrow in our thinking. And everything that we try to do in New York is premised on the fact that lawyers matter. But that doesn't mean that other people can't help in solving the justice gap. So what we're doing in New York is, and this is really to some degree based on the British model, you know, they do a lot of this, a lot of civil legal services is done by non-lawyers. The Professor Hatfield out at USC, very active in this area. It's done by non-lawyers and done quite well. And in so many areas that we deal with in the courts, 98, 95, 99% of the people are unrepresented. We're not doing the job. What is the harm of having a non-lawyer who's trained to come in and do this? We are putting these people into the courtroom. They're called navigators. We're doing it first in housing and consumer credit. We're putting them into the courtroom where they can provide moral assistance to the litigant. They can provide information. They can answer the judge's questions. We have specially trained judges who understand that this could be of assistance. And, you know, I think it's going to really do very, very well. We've had, while the bar was at first very suspect about it, they've come, they've taken a look at the work that these specially trained non-lawyers do, and they see it's only good. It's only helpful. There's nothing negative about it. We're not taking away anyone's business. We're trying to think out of the box as to what we should be doing. I think all of this thing with non-lawyers plays into what Deborah has been so concerned with, this idea of the practice of law and what it means. We don't know what it means. Judiciaries around the country, states that have tried to figure out what the practice of law is, we don't know. We give up after a while. It's very hard to really pin it down. So we're going to be looking at that, looking at the regulatory scheme, looking at where we really should be, what we should be doing with the legal profession. And again, the critical importance of lawyers. This emphasis on pro bono, on funding of providers. So obviously lawyers are critical, but again, others can be helpful, and we're going to do that. We're going to look at what the practice of law means. There are interesting things going on around the country. The state of Washington is doing this legal technician, which is kind of a low bono, less than a lawyer, but yet they get paid, but the prices are lower than lawyers. So I think there's a lot that maybe for the people who really can't afford it, for the middle class, putting aside those who are, at the poverty level or close to it. I think there's a lot of work to do along those lines. So those are some of the things and the different things we're doing in New York, you're doing here in California, a lot of the emerging issues. But where is it all going? What's the goal here? What are we trying to accomplish at the end of the day? Let's see if we can pull together some of the strengths. Obviously, we use the term civil Gideon. We have the civil Gideon pilots here in California. What is civil Gideon? I don't know. We're sure. I've tasked our task force to come up with a template, maybe that we'll submit to the legislature. We don't want to kill the golden goose for giving us enough money, but maybe aspirational. Maybe what it means. What is civil Gideon, and how do we get there? I think the answer as to how to get there is really what we're doing now. Kind of the 1,000 flowers blooming idea, that different things are happening around the country that are really making a difference. And we're really starting to see that. Because to me, you'll get a civil Gideon at some point, one of two ways. If either the law evolves to the point where you're going to get a civil Gideon, or the public demands that there be representation for people dealing, again, with the essentials of life who have no lawyer. If you look at, what we really have to do is change the dialogue in this country. Look at Gideon. Look at Betts versus Brady. 20 years before Gideon, the Supreme Court of the United States said no right to a lawyer, even when your liberty is at stake. And in the 20 years between Betts and Gideon, the dialogue changed. Interesting things were happening in different states related to criminal representation. 20 years later, and Gideon, as flawed as Gideon is 50 years later, as uneven as the representation is on the criminal side, you have a flaw that everybody whose liberty is at stake is entitled to a lawyer. How could that not make sense? I mean, to me, it does. And here and now, in this country, the things that we're doing in the different states, the access to justice commissions, the bar task forces, the civil Gideon pilots in Texas, the Chief Justice negotiated a rise in the IOLTA rate, in order from the banks, in order to get more money to the provider. In Connecticut, there's a new fellowship program where the big corporations, the House in Delaware, are funding recent graduates to come in and do pro bono work, and they'll pay for it. In the state of Washington, we talked about non-lawyers. In New Jersey, been very active on foreclosures and getting representation in foreclosure cases and changing the protocol. Montana, California, New York, New Jersey, New York has done it, looking at 50 hours in the other case. In consumer credit cases, we've just issued in New York all kinds of new protocols for making sure that the consumer credit process, which is generating all these default judgments, these consumer credit outfits buy up pennies on the dollar, these debts, and come in with some kind of hearsay affidavit and a number on a spreadsheet, get a default judgment, and all of a sudden you see your wages garnished, or your bank account frozen. We have to, in all these ways, contribute to leveling the playing field. Immigration cases, Judge Katzman in the Second Circuit of New York, a great new program to provide representation in immigration cases. The ABA, Jim Sillickman, the president, has made it his key, most important priority, this issue of access to justice, how we provide representation for the poor. All the things I've talked to you about, what we're doing in New York, what you're doing in California, all these things are changing the dialogue and changing the priority. That's what we're doing here, the reprioritization of what's important in society and legal representation of the most vulnerable among us is, by any standard, has to be the top of the list again with all those other things that we think are important. And I think by changing the dialogue, by really getting our message out, the people's viewpoint about this, look at criminal case. If you took now, 50 years after Gideon, if you took a survey of people and said to them, listen, do you think someone whose liberty is at stake should have a lawyer? You got 95% of the people in this country say, absolutely, without question. All they have to do is watch television. And they know, all these programs where, oh, yeah, you have a right to a lawyer. It's basic. We understand that now. And you know what? I would say today, with all of the attention on the bad economy, things like the foreclosure crisis, if you ask today, people say, if the roof over someone's head is at stake, do you think that they should have a lawyer? They have a right to a lawyer? I bet you overwhelmingly people would say yes. So it's an evolving process. It's changing the way people look at it. I believe there is absolutely an access to justice revolution that is taking place. We're shifting the landscape into New York and California, around the nation. I think there's absolutely nothing to be discouraged about. It's the opposite. There's really interesting, important things that are happening. We're making progress. We have a long way to go. But that same thing I talked to you on the criminal side, with those 20 years, the whole view of criminal representation changed. And I think, from my own perspective, the judiciary should be, the leading, a very, very significant leadership role on this issue. We should be using our pulpit. We should be using the power to regulate the profession, to help shape the values of, again, a noble profession, to aspire to the highest levels of what we should be doing as lawyers. As the doorkeeper on bar admission, we should be helping to rethink judicial education. We should be making a record. We should be holding hearings. We should be making rules. We should be focusing on this issue, which above everything else defines our profession. It's what we are all about. And if we can't be about that, then the profession really isn't worth anything. And that's the bottom line. This is what it is to be a lawyer. So all of us have a role to play. I think we're having, and we can have, a tremendous impact. But I think it's a partnership. And I think it's the judiciary, it's the profession, it's the academy, it's the providers. It is everybody, and no matter what role they have in the legal community, we all have to be working together. And I truly believe that by doing that, by getting our priorities straight, by getting out there, by putting the focus on access to justice for everybody, regardless of the resources that they have, I truly believe we can make the ideal of equal justice a reality here in California, in New York, and around the nation. I'm so delighted to be with you today and work together with you toward that end. Thank you so much. Thank you. Thank you. Thank you. Thank you. Thank you. So, who has a question? Yes. 100 degrees, how could I resist? Sure. It's a rare combination. Go ahead. Pennsylvania, New York and California, is it so rare? Yeah? Look, I think you're talking about a subset, particular field of litigation, and I don't believe making generalizations. Corrupt is a very strong word. I think perception is important, and if your point is the perception of justice is as important as the reality, and if there are certain perceptions in this great legal profession, and as much as we are trying to change it, and all for the better, and there are things that can be improved. I'm a big defender of the legal profession, and I don't believe that lawyers take their ethical responsibilities lightly. I think there are particular instances, like in any profession, where we have, people who are at the highest level and others who are not. So I think it's very hard to make generalizations. But look, I believe that the justice system has to make sure that, again, the reality as well as the perception of justice is there. And that is our responsibility. And I believe that whether it's the judiciary or the profession, I think the self-examination is important. But, I think the broad generalizations about, lawyers, and you look at a lawyer and say that lawyer is, if I hire that lawyer, that's a good thing. A lot of times we hire lawyers because they're the best at what they do. And my view is that what I'm really focusing on is that people who can't hire the best, who can't afford to get a lawyer, need to have representation. So that's my focus, but I certainly don't diminish the point you're making, that we have to, of course, always be looking at ourselves and always make sure that the perception and the reality of justice is at the highest possible. Who else has a question? You got to have a question. Dean McGill, you have a question. Go ahead. This is great when, the judge can call on the academic to answer a question. And she's sitting right in front of the room where she can't avoid it. Go ahead, Dean. What's your question? Well, I know California is looking at it. I do think that again, I was kind of, this Professor Hatfield that I mentioned to you, I saw her give a lecture at Harvard a couple of years ago, and it really started me thinking, I really wasn't aware of this. And in parts of the world, this is what people do, and lawyers aren't the people doing this. There's these little things going on around the country. We were doing some things in New York before we decided to do this major pilot. Washington, state of Washington, is very interesting. I keep hearing about it, but it's not going to kick in until 16. So I think there are states who are raising the ante on this and really getting it out into the public. I think you'll see in the coming months and years, a lot more major projects. Deborah had asked me yesterday how we're evaluating. I think when you do things that are kind of outside of the norm, well, you know, how is it working? So for our particular, there's a group that is going to fund an assessment of our work in New York and the Washington experiment on non-lawyers, and see how that goes. But I think it's obvious that if you're not doing the job with, you know, the way we're doing things now that says it only must 100% of the time must be a lawyer, and let's look out, you know, let's think outside the box. Let's look at what can be done. And again, I see no reason to believe that if you really are trained in a particular narrow area, that you can't. And again, this goes to this issue of practice of law, and we don't want people who are not lawyers practicing law. But what does it mean to practice law? I think is a question. So I think you're going to see some major developments in that area, and I think here in California, you're going to see some of it. Yeah. No, thank you. Right. Right. Yeah. Yeah. It's easier than.
I can't collect my fee.
Yeah.
So that doesn't count.
Yeah.
What does count, and do you audit these claims? How do you make all
Yeah.
this work?
It's easier than you think. You know, we had an implementation group that went and looked at this issue. There's a one-page form that the supervisor fills out as to that the student has done the pro bono, the nature of the work. It's not very complicated, but they have to go through the bar admission process. To the extent that we want to ask additional questions, we can do that in the course of bar admission. We're finding it a lot easier than some of the forecasts that this would be a bureaucratic nightmare. It really is relatively simple and easy to do, and I don't think it's going to be. We're basically doing it through existing resources, personnel, and it's not a great problem. What we are trying to do is making sure that everyone. Yeah, one of the problems we've had in New York, and I don't know if it's a problem out here in California, is getting students who are applying for admission through more quickly. Because sometimes it takes 6-9 months to get them admitted. They're already having trouble finding a job, and they don't have bar admission. So that's something that may require more resources to get people admitted more quickly. But as to the 50-hour in general, we've I think gotten it down, and we're going to be talking with your folks here in California and with the bar about this. I think it can be done relatively easily. So, yeah, John.
I wonder if you have a comment on this. I make the observation that one of the challenges in accomplishing what you're talking about is to convey accurately what we mean by pro bono. Because I think many people have an idea in their mind what it means to do pro bono service as a lawyer. We call up images of Clarence Darrow and people in the courtroom. Of course, that's pro bono. You go into the court with a client and you do the trial. Well, the truth is that pro bono service happens in a vast array of different ways, only some of which happen in the courtroom. And part of the challenge is introducing to as many lawyers as possible the idea that you too can do and be enormously
Yeah, we've done, to be quite honest, we've done it with wider or narrower definitions depending on the program. With the law students, we made it broad because we wanted to inculcate them not only just legal services for the poor, but public service. When we did the pro bono reporting requirement, we've made it narrower and say, we want to know what you're doing for the poor. But I think you're right. The definition is critical, and you have to make a decision as to how you want to sort of frame this up. I don't think there's any magic. I'm most interested in legal services for those people who can't afford it, for the disadvantaged, for the vulnerable. But I think, as you say, there are lots of forms of pro bono. And one of the issues that we've had in New York on the reporting is the bar feels it's a little narrow, and that we should widen it to give them credit for more kinds of service. The defining thing, which I think is important to keep in mind, is that the client doesn't pay for it. That really is an important thing that we think, is very, very important. So, yeah.
25% of the underprivileged need civil legal services connect with them. Does your program, other than requiring the work, does it have an outreach or a connection to find those people and make sure that they know that they can get services?
Yes, but the problem is that a lot of them know about it and get turned away. I mean, that's the reality, is that the most well-funded legal services organization is turning away people left and right if there's just no resources. So our emphasis is on getting money to the providers so they can provide more service. But you're absolutely right. You have to let people who maybe are not educated or don't have resources understand how they can get legal service. Language issues are very important, and yes, we've been working on it. I think Lucy just got up for a reason. I don't. We only. Sure. Yep. Go ahead. We'll finish now. Glutton for punishment. Go ahead. Yeah. Yeah. Well, again, our strategy and what we've done, and I think has been successful, is to not go with our hands out and say that we need the money because this is the right thing to do, and that you have to, help poor people with legal representation. We've tried to explain to them why it's good for the state, why for our government, for New York, that legal services for the poor be supported. So I think it's finding out new ways. It's the old ways that we were doing, and and I'm not exactly sure what they're doing out here, to just say you need to do it because it's the right thing to do. It is the right thing to do. Is not enough. We did also with our hearings, we connected it to economic studies about the benefit to the economy of pro bono with domestic violence or housing. So I think you got to give them an empirical reason aside from their conscience. You got to give them dollars and cents. Okay, thank you so much. Appreciate it.